Thank you. So my name's Charlotte Pritchard. I'm a Senior Associate Solicitor at Irwin Mitchell Solicitors based in Manchester, and here's a few photographs of my team. So Christine Thornley is the partner who heads up our team. I'm a Senior Associate, as I've mentioned, and then Fiona Bushell is an Associate Solicitor and Danielle Burgess is our Solicitor. We also have a paralegal joining us next week, actually, and we have a fantastic team PA called Jack, who's there to support all of us and to help any of our clients whenever they contact us. We specialise in the administration of estates, so sorting things out after somebody has died, but also the preparation of wills and trusts and lasting powers of attorney. And even I've spoken about lasting powers of attorney, and I've said that I'd be happy to come back and speak to you another time, hopefully with improved technology next time. But I'm more than happy to come and speak about lasting powers of attorney, their importance, how they should be created, and what they can be used for. But the intention of today is to discuss wills. And so statistically, 50% of the UK adult population doesn't have a will. And this is important to bear in mind when we consider that every 90 seconds someone is admitted to hospital in the UK with an acquired brain injury, meaning that they are then not in a position to create a will. And in the absence of a will, a person who dies is relying on the jurisdiction and the rules of the country as to what happens to their estate, which to an extent is like rolling the dice, because most of the people that I speak to are either tell me that they're happy for their estate to just pass under the rules of intestacy, but then when I ask them what those rules are, they invariably get that wrong and don't actually know how their estate would devolve. And I think what perhaps is a worst case scenario for any of us to consider is that in 2022-2023, £11 million went to the Treasury through intestacy. So this is where somebody hasn't made a choice of beneficiary. There is no bloodline or remoter descendants, so long lost cousins, the people that you see on these air hunter programs. No one could be tracked down, and ultimately it goes to the Crown. So it goes to the royal family. And we have something amazing in this country, which is called freedom of testamentary dispositions. It's not the sexiest of sounding things, but it means that each of us are free to leave our estates to whoever we wish. And that's our right and our entitlement to do that. And that's not the same in every jurisdiction. There are some jurisdictions which have forced heirship. So, for example, the first third has to go to a spouse, the second third of your estate has to go to other family members, and they actually only have freedom over the final third of their estate. But in the jurisdiction of England and Wales, there is 100% freedom of testamentary disposition. So we can leave however much we want to whoever we want, without there being any recourse, provided that we had sufficient mental capacity and everything else to be doing that. The way that it's actually handled in the jurisdiction of England and Wales is that there are a category of people that can bring a claim for reasonable provision if they've been cut out of a will, if that's the terminology we're going to use. But it's for them to bring a claim against the estate to be adequately provided for. The obligation isn't on the person who's making the will. The other thing that a will does is allow us to appoint executors, so we can appoint people to make decisions on our behalf and to administer our estate after we've passed away, to make sure that the assets are collected in properly, any debts are paid. They would arrange our funeral as well, and then put the inheritance in the hands of those beneficiaries. So if we don't choose our executors, it's chosen for us by law. It generally flows in the same way that inheritance flows, which is that a spouse would act, then children would act. In the absence of a spouse and children, parents would act. In the absence of parents, siblings would act, and so on. And we know from, I'm sure from ourselves, our own lives and the people that we meet, that not every family has that happy story where we would like those people to be the ones that are acting for us. Sometimes we're more private, sometimes we have people who would just make a better choice. For example, I have one sister that would act better than another sister because of abilities, but also demands of jobs and family life and so on. And so it's an opportunity to actually speak to those people and say, will you be my executor? This is why I'd like you to be my executor. And where we're creating a trust in a will, which I'll talk about a little bit more in a while, they'd also be appointed as the trustees as well. In your will, there's also an opportunity to give an expression for your funeral wishes. This is only an expression of wishes. It's not legally binding and can't be legally binding, because you could say, I want to have be buried in a golden casket and for there to be a day of national mourning, or I like to have a Viking burial on the Thames. You know, we can't make those things legally binding, but we can put in our expression of wishes, be that I wish to be cremated, I wish to be buried, I wish there to be a Catholic service, I wish there to be a humanist service. So whatever you would wish, it's an opportunity to express those wishes. And to be quite honest, it's one of the main areas of conflict that I see, either because people in the family have strong beliefs after someone has passed away, or simply because the deceased didn't communicate or didn't communicate consistently what it was that they wanted to do. So if this is something that can be ironed out by being on the face of the will, then that's just better for everybody to have those expressions in. That being said, many of my clients leave this blank and decide not to include anything and say whatever anybody wants to do is absolutely fine by me. So that's a personal choice. There's also the opportunity to appoint guardians. So guardians are appointed when somebody has passed away and left minor children. And importantly, it's when there is no other person with parental responsibility. So quite often people say to me, well, if I were to die, I'd like my mum to have parental responsibility and be a guardian, or I'd like my sister or my brother. And they omit the fact that there's actually a child's father. It might be an estranged father, but if that father has parental responsibility, either because they're on the birth certificate or they were married to the mother at the point of birth, then they would have parental responsibility. Now, that's not to say that a person's election of guardians in their will is pointless until both people at the parental responsibility have passed away, because if let's say, for example, grandparents were appointed as guardians and it was a mother who had passed away, the father then might say, well, I would have to uproot the child and move them to another part of the country, a different school and everything else. Actually, I would prefer that things stay as they were. They continue going to the same school. Grandparents were involved anyway. And that arrangement is well supported with social services and with the schools by seeing what the deceased wanted in their will as well, who they would have chosen as guardians. It speaks the same story. So although the guardianship clause doesn't take effect until every person with parental responsibility has passed away, it is an important expression of wishes that can be used to support any applications or any arrangements that follow the death. And then finally, in our will, we can set up legacies, so be those specific gifts or specific items. So I'd like my jewellery to go to this person, I'd like a painting to go to this person, I'd like £500 to go to these people. I would like to leave everything to my next door neighbour, I'd like to do everything to my children, but not until a certain age. Or I would like somebody to be able to continue to live in my house, but when they die, I want it to go to somebody else. So these can be instant arrangements of handing something over, or they can be longer term arrangements. And I'm going to talk about that in a bit more detail. I have already covered this, but this is just the flip side of this. So what happens when we don't have a will? The rules of intestacy apply. This is written in law, who inherits. A lot of people think that if they don't have a will, and they're married, the surviving spouse will just inherit everything. And then on the second death, it would just go to the children. That isn't actually the case. For a lot of people, it is. If your estate, so the amount that you have when you die, if it's less than £270,000, then yes, everything would go to your partner, to your spouse, sorry. If it's more than that, all the personal effects go to the surviving spouse, and the first £270,000 of the estate, which is called the statutory legacy, and then half of the remainder goes to the spouse and the other half would go to the children. So if you take an example where you have a property that's, I'm going to make up a number, but let's say a property that's worth £500,000, and it's all held in the name of the deceased, the personal effects would go over to the surviving spouse. £270,000 of value of the house would go to the surviving spouse, but the remaining equity there, which is £230,000, would be split between the spouse and the children. So the children would be acquiring an interest in the property on the first death, which probably isn't what the couple had in mind and what they wanted to do. Particularly if they're minor children, that's a bit fiddly, and you have to have them represented as well for that to be administered. So far better is to have a conversation about that and what you'd actually like to happen. Again, appointments of executors and trustees, so you have a choice as to who deals with it. If you don't have a will, then it's set out in law. The point again about appointing guardians to make decisions for children, and rather than leaving that in the lap of family or social services to actually be able to express those wishes. And again, choice of beneficiaries. I often have the case where people don't realise that an ex-husband or an ex-wife is going to inherit, because although they're separated and have moved on with their lives, in the absence of a will, that spouse is still considered under the rules of intestacy, and so the assets can pass to that spouse. I also see cases where inheritance is split between children equally, adult children, and actually one of those children is bankrupt, and so it's just lost the trustee in bankruptcy rather than being put in some sort of protective wrapper for when finances have settled down. I've also had it where inheritance is passed to children who are in unstable relationships and are about to head into a divorce, and therefore it becomes matrimonial assets and then is lost through divorce proceedings. And also consideration to the specific needs of beneficiaries, such as any vulnerable beneficiaries, any beneficiaries that are in receipt of means tested benefits. Do we really want them to be receiving an inheritance? Or do we want to be thinking about something a bit more carefully so that they can still access their mean tested benefits, but also still receive an inheritance over a longer period of time to support them? And I'm going to talk about that a little bit more as well. So hopefully that sets the scene about what we're going to talk about and why we're going to talk about it. And I thought the easiest way to do this is to perhaps give you a few case studies, a few examples of where people have passed away either without a will or with the wrong type of will, and what's happened as a result and what we could have done to make things better. So the first example is Mrs. I've actually called her Ms. C because she's technically divorced from Mr. C. So she's divorced and is cohabiting with her new partner, and she has one child aged 15 with her ex-husband, and that child lives with her and her new partner. They own a property on the Wirral and it's in her sole name, so they're living together as sort of a modern family. Child still seeing their father, but day to day it's the child, the mother and her new partner. And then Ms. C dies unexpectedly in 2023 without a will. So who is entitled to probate into the estate? So as there's no will, there's no executor chosen by Ms. C to deal with her estate. So instead, we look to the laws of intestacy to determine who is entitled to take out a grant of letters of administration. So this is going to be the person that has all the bank statements sent to them, has all the outstanding bills, the credit card debts, all of those kind of things. Now, because the person entitled to inherit is her child, so when someone dies without a spouse, because she's divorced and not remarried, but with a child, that child is entitled to the whole estate at the age of 18. And actually, if they marry, it's the age of 16. So if they were to go to Gretna Green and marry at the age of 16, they could take their full inheritance. The person who would have to act for that child is the other person with parental responsibility, and that person is ex-husband. So ex-husband is now going to have all the bank statements and credit card statements diverted to his house and to administer this estate on behalf of their child. Equally, no provision has been made for Miss C's partner. They were living together as a family, but now his situation is up in the air. He does have a potential claim for reasonable provision against the estate. So I've mentioned this previously to say that whether you have a will or not, there's freedom of testamentary disposition. Where something has played out that isn't quite reasonable, and we would say here that Mr. C now, that Mr. C's partner now doesn't have a roof over his head potentially, he could claim that that's unreasonable, but effectively he's fighting the child for their inheritance, because if he didn't bring a claim against the estate, then the child would inherit and it could be in a trust fund up until that time. Not only is that not a great situation for relations, but also it's very costly and acrimonious to bring a claim against an estate. So we would want to avoid that, and we could avoid that by having a will. So as I've mentioned, the child wouldn't be able to take out a grant from the court to administer the estate. Mr. C's ex-husband would be the person with parental responsibility to extract. He would need to appoint a co-trustee, so he would appoint someone to act with him. You'd like to think that everything is happy families and he would appoint the partner and they'd work collaboratively, but that's unlikely. He could actually appoint his new partner, for example, or somebody else that Miss C wouldn't have chosen to look after these funds until her child is 18. And as mentioned again, because it's worth hammering home, the laws of intestacy do not recognise unmarried partners. So anything that you hear about common law husbands, common law wives, it's something that people talk about, but in law, particularly for intestacy, it just does not exist. And we've got this situation where a child, and I think any child is vulnerable when they have lost a parent and are receiving an inheritance. We've got a vulnerable child inheriting the whole of this estate at 18, having to deal with the issues that with their partner, their mother's partner, also dad on the scene as well, and the loss of their mother. So what should she have done, or could she have done? She could have created a will, making provision for her new partner, for example, allowing him to live in her property for the remainder of his life. And we can create that in a way to say that if he needed to move or needed to downsize, then that he can take that interest to a new property. We can also put a clause in to say, or until he remarries. If he remarries or marries, then it's the end of this arrangement, then his life's moved on and it should pass on over to the child. Or it could be until the child reaches a certain age, so a contingency. Once the child is 35, that's enough time for you to have sorted yourself out, or 21 when the child has finished education. What we can tailor this to be any way that Miss C would have wanted it, to make sure that her partner is adequately provided for and then her child is adequately provided for. We can consider that age of entitlement the child I've just mentioned, so rather than it being 18 or 16 if they marry, it could be 21, it could be 35, it could be 50. I've seen 50 before. That didn't go down too well with that family, but I have seen that. She can choose whether it's an outright gift, so when you reach the age of 21 you will get your inheritance, or it could be, I've seen things, and these have to be reasonable, but I've seen things like an old-fashioned one we used to see was when my daughter marries, she can have it. Some of them have been contingent on completing certain qualifications or spending a certain number of years in the family business, and that's when they then get their inheritance, or into a trust. And this is something I think probably we'll talk about a bit today. If the inheritance goes into a trust, it means it's held at arm's length from that beneficiary and is looked after by somebody else until that child is ready to take their inheritance. And that can be a flexible arrangement. So rather than it being at the age of 21, at the age of 25, it can be at a time that you as my trustees think it's appropriate to hand over the inheritance, or hand over in stages, or take consideration to their friendships, the stability of their life before making any distributions of capital to them. And as mentioned before, selecting her own executors, and importantly, when we're talking about a trust, selecting her own trustees as well. I've got 2 more case studies. Does anyone have any questions at this point? I was going to do questions at the end, but I'm just wondering if anything's cropped up there.
I can read the questions. Just a second. So we have a question from a participant.
And charity requests come under legacies, so I wanted to leave money to the BSF. Yeah,
Yes.
so when is that the one that you're seeing, Eva?
Yes, and then they have a
Yeah.
a
So
direct
when I talk
question.
about
Mhm.
Okay, so when I talk about legacies, that was just a general term that I was using for disposing of something, disposing of your finances and your assets to people. But legacies can be a sort of fixed amount. So I want to leave £1,000 or £200 to specific places, or it could mean a percentage of your estate as well. We generally like to work in percentages, and the reason for that is you could say that you wanted to leave £5,000 to a relative or to a charity on a day when you've got £500,000, but your life goes on and you spend that money and that pot gets exhausted down to £50,000. Well, then we're talking about a gift of 10% of your entire estate to a person or a charity. And is that really what was intended when that person actually created their will and was comparing their legacy versus the size of their whole estate? So that's something that we were talking some detail about. It's also giving to charity. It can be really effective for inheritance tax planning. I'm not going to talk a lot about inheritance tax today, and if that's something that you would like to cover at another time, then I'm more than happy to. But inheritance tax, as in a nutshell, is a tax that's payable after the available reliefs have been exceeded. So we can each leave £325,000 without having to pay any tax. And if we have a property, that could increase to £500,000 if leaving it to children. But where we exceed those limits, inheritance tax is paid at a rate of 40%. Now, if we know that an estate is going to be subject to inheritance tax, something we can do to reduce that rate from 40% to 36% is to leave 10% of the estate to a charity. So I know that there was a lot of numbers there that I bandied about quite quickly, but the principle behind that is if we know an estate is going to be subject to inheritance tax, it can be wise to suggest leaving a legacy or a gift to a charity because it will reduce the rate of the inheritance tax to be paid. So I hope that answers that. And I don't know either if you have any sort of direct, oh, there we go. You're more than welcome. If there's any other questions about legacies there or about gifts to charity, then I'm happy to talk about that at the end. And then did you say there was another question, Eva?
Yes. Yes, so we have a message from a lady. She lives alone with her child. So the question is, if I die, I would like to know what executors, people to oversee the dead abroad, who will they be? Do I pay a solicitor before I die, etc.? And single mothers are a rising household nowadays. That's a very good question. Yeah.
It's a really great question. And my third case study is this situation. So can I hold off answering that until we've done the third case study, because it might get answered by that, and then I can answer any questions that arise from case study 3. So I'll move on to case study 2. So this is Mr. S and Mrs. S. They've been married for 10 years. Mr. S has a child to a previous relationship, age 12, who lives with Mrs. S, the mother. Mr. and Mrs. S have one child together, a daughter, aged 5. Sorry, and let me just go back to it. Mr. S has a child to a previous relationship, age 12, who lives with his mother. So Mr. S's child doesn't live at the family home of Mr. and Mrs. S. But Mr. and Mrs. S do have one child together, a daughter aged 5. Mr. S dies, and he does have a will, and it follows a short illness in 2023, and he leaves everything to his wife. And they had agreed that Mrs. S would leave everything to the 2 children equally when she died, so her own child and her stepchild. Mrs. S outlives Mr. S for many years, and her relationship with Mr. S's older child dwindles. Mrs. S leaves her entire estate by will to her own daughter, making no provision for Mr. S's older child. And this is something that we see a lot. This is called sideways disinheritance. So it's where, with the best of intentions, people leave everything to each other and say on the second death, please cater for all the children equally. And then life happens and gets in the way, and things evolve after that first death. We know that it's a very difficult and fragile time for people. It's a time when arguments can sometimes start and never be resolved. That's not the case here. This is just that Mrs. S's obligations, she felt that they changed. She's not had contact with Mr. S's child for many years, and that child is settled and fine as far as she is aware. But this isn't what Mr. S wanted to happen. So, is it what he would have wanted? No. Mr. and Mrs. S had agreed that their children should benefit equally from their combined estates on the second death, so when Mrs. S dies. But as Mr. S had created no trust in his will, Mrs. S was free to leave her entire estate, which included his, to her own daughter, to the exclusion of Mr. S's son. So what should they have done? So Mr. and Mrs. S could have created mirror wills, those that reflect each other, and left each other a life interest in their estate. So the intention would be that they would provide for the surviving spouse, in this case Mrs. S, for the rest of her life, but ensured a legacy for Mr. S's son on Mrs. S's death. So when Mr. S dies, Mrs. S can carry on living in the house. She can move house and downsize, but she hasn't taken ownership of his share of anything outright. So she can't leave it to anybody else. She simply has what's known as a life interest. So for as long as she's alive and needs it, she can occupy his assets. However, on her death, her freedom of testamentary disposition, her freedom to leave her estate, applies only to her own assets. So she can only leave her share in the property to her daughter. She can only leave her share or her bank accounts to her daughter. Anything that was held on trust, so anything that she used during her lifetime but actually belonged to her husband when he was alive, would pass to the children equally, because that's what they agreed. So even though Mrs. S has changed her will to say that her daughter benefits to the exclusion, at least Mr. S's son would have half of his estate had he created a trust will. And you'd hope that that doesn't happen. You'd hope that they would both have wills that create life interest trust for each other and remain that it goes to the children equally on the second death. But the survivor will always have that freedom to do whatever they want to do with their own assets. Okay, so this is the case study that perhaps is similar to the person who's asked their question. So I'm sure some of the facts differ, but this is the situation I've created that hopefully will eke out some of those answers. So this person is called Mrs. F, and she lives in a house that she owns with no mortgage worth £300,000. And Mrs. F has a 13-year-old disabled daughter who lives with her. Her daughter is in receipt of means-tested benefits and is unable to manage her own finances or to meet her own care needs. There is no other person with parental responsibility for her daughter, as her father passed away shortly after she was born. Mrs. F dies without a will following a brief illness in 2023. So what's the impact on the daughter of having not prepared a will? So there are no executors appointed, so nobody has been selected to act to administer the estate for the benefit of the daughter. There's no guardians appointed, so nobody is automatically appointed to have parental responsibility. The means-tested benefits that the daughter is in receipt of will be affected by the receipt of the inheritance, because the capital element of that assessment will change because she receives an inheritance. And by leaving, I've mentioned this before, that I consider any child, so anyone under the age of 18, but I would extend that to older, anybody who has lost a parent, I think is vulnerable, particularly the younger children or teenagers. So I would say that this child is open to abuse. She is a vulnerable beneficiary. Potentially teenage years, she might hit some poor life choices. There are potential safeguarding issues as well if she has a huge amount of inheritance at her disposal, and she may be taken advantage of by strangers. Can I just say that before we started this, I spotted this typo. I always get my and by mixed up. It's just one of those things that happens, and I didn't have a chance to change it. So I am aware that this has taken advantage of my strangers rather than by strangers. And I'm happy to circulate the slides either, so I'll make that amendment before it circulates. I think, yes, so this does then deal with what should she have done and how would a will have helped, and I think this perhaps will answer that question for the lady who asked. So she could have chosen her executors and consider professional executors. So professional executors can be solicitors, they can be financial advisors. I would say that if the reason for the appointment is more to do with emotional decisions rather than financial planning decisions, that perhaps a solicitor would be better placed because of their experience in dealing with these scenarios and also dealing with any contentious issues as well. If you appoint professional executors, they are always going to charge for their time, and they're never going to say to you, it's going to cost this amount every year, because acting as an executor and a trustee, so an executor is collecting any assets and transferring it into the hands of the beneficiary or into a trust, and then the executors put on their trustee hat, which means they're looking after it if it's not going out right to a beneficiary. Quite often we find that at the beginning of a trust, while we're sorting out who do we need to consider, what did the deceased want, where's the best place for us to put the money, when's the next time they're going to need money, do we need to distribute any capital, when do we so setting it all up and getting the trust in place, there's quite a lot of legwork to that. So at the start, the professional fees are going to be relatively hefty compared to how the rest of it then plays out. Because if it's set up correctly, largely it should manage itself, with the trustees reviewing it annually for reporting purposes, but also just responding to any requests from likely the guardian or a child if they're a bit older. So the guardian might say, there's a school trip coming up, and we need some money from the fund to be able to fund this school trip. It would be really great for educational need, educational advancement. Or it could be the trust doesn't pay out the capital until a child is 18. In this case, we have the child in receipt of means tested benefits, so whether we would ever transfer the capital is another matter. But it might be that we're not planning to transfer out any capital until age 25, but the child wants to have driving lessons at 17, and so maybe the trustees would send out funds to pay for driving lessons. And then to ring fence inheritance to shelter the funds from the necessary benefits assessment I've already spoken about. Sorry, I've missed appoint guardians. So who would acquire parental responsibility and make decisions for the daughter about day-to-day decisions in the same way a parent would. So the appointment of a guardian is exactly that. If you think parental responsibility, if you think of the day-to-day decisions that parents make, so it's things like permission to go on school trips, it's things like dietary choices, whether a child should have particular dietary choices for religious reasons, for health reasons, vegetarian, vegan, halal, all of those kind of decisions. A parent with parental responsibility can give those instructions to a school or a place of learning. Also day-to-day health decisions, making sure that they go to the dentist, making sure they go to the doctor, making sure they take the medicine, and then more serious things, so consent and refusal to medical treatment, and who should see the child, who can't see the child, all of those things the parent makes decisions about. And I think that's a huge responsibility and a right to be able to make those decisions. And I think it's probably remiss if you have a child to not consider who should be making those decisions for you, if you're not around to make them for them. So I think the appointment of guardians is really important for anyone who does have a child, so that you can actually select the person that's going to be making those decisions. And by doing the will, Mrs. F could have chosen who would be doing that for her daughter. And again, this has been picked up by in the chat, who said that he works in children's services and agrees 100% all children in this situation would be vulnerable, especially if it's a young child or disabled child. So again, that vulnerability, by appointing executors and trustees and guardians who can work collaboratively, we can protect this inheritance from financial abuse from friends. And I know that sounds awful, but we do see that. Family. And actually going back to friends, when we say friends, it could be pre-existing friends or perceived friends of a vulnerable person. Family, so we do see sometimes exploitative behaviour, and strangers who get wind of the fact that somebody's got access to large sums of money. And so by creating a will, Mrs. F could have secured this legacy. And when I use the term legacy, just to be clear, I don't mean necessarily a fixed amount. I mean it's in general terms of leaving something to her daughter, but throughout her life and for the remainder of her life. So I want to give some time for some questions if people have any. So I'm just going to end by saying really to remember that everyone should have the appropriate estate planning in place, because it ensures that you can provide for your families in the most suitable and tax efficient way. And whilst we as solicitors understand that it's not always easy to talk about estate planning matters, especially wills, it really is a sensible thing. And I hope that some of the examples today have been a bit of food for thought. So if anyone's got any questions now or after, I'm more than happy for people to contact me directly or through you, Eva, if that's easier for people to contact me if there's something that crops up after today. But otherwise, I'm happy to take any questions.